may know and have read from our advertisements on this. Deborah Greenspan is a partner at Blank Rome in Washington, D.C. She served as the Deputy Special Master in the 9/11 Victims Compensation Fund. She did that for 9 years and was responsible for developing terms, guidelines, and protocols for evaluating claims and providing compensation for the victims of those terrorist attacks. She also served as special master evaluating damages in several cases involving claims by other terrorist attacks conducted outside the United States. She has extensive experience in creating compensation systems, analyzing claims, and working with constituent groups to fashion resolutions in situations involving mass tort claims. Currently, she is the special master in the Flint water cases involving claims of damages related to contaminated water. She's a member of the board of overseers for the Rand Institute for Civil Justice. And as I said, she is the president-elect and on the board of the Academy of Court-Appointed Neutrals. So I think that's all the time we have. Thank you, everybody, for showing up. But Debbie, welcome to Texas, at least virtually, and thank you for being here today.
Well, thank you for inviting me, and I'm very pleased to be here. And maybe someday we'll actually get to Texas and do this in person, or have a nice time to meet with everyone in person. But thank you so much for having me here.
No, absolutely. And, as I said, this is co-sponsored by 3 different groups, all of which you have members who have ADR backgrounds, whether it be mediation or arbitration, or frankly, might be lawyers who participate in mediation or arbitration representing clients. But we've talked about your role at the Academy of Court-Appointed Neutrals, ACAN. So not everybody here, I don't think, knows what a court-appointed neutral or a special master is. So, starting out with the easiest of softballs, what is a court-appointed neutral?
Okay, well, yeah, we'll start there. Court-appointed neutral is sort of a newer term that's being given to what you might have previously known as a special master. And it's a special master is a term that's used in the federal rules. Various states have analogs, but often use a lot of different terms to describe the same function. So in federal court, the easy way to describe this is it's Rule 53 of the Federal Rules of Civil Procedure, and the court can appoint somebody to be a special master, and there are certain guidelines and requirements about being put in that role. There are conflict rules, so you can't, basically the same rules that apply to a judge, but the roles can be quite varied. And I think when we think about neutrals, we usually first think about mediators. So somebody's come in to help facilitate a resolution, and that is one of the roles of a court-appointed neutral. And I think probably everybody has had some familiarity with a court mandated mediation, or a court telling the parties, I'd like to appoint somebody and I'd like you to engage in some sort of mediation process. And it could be for a whole variety of purposes. It doesn't have to be for every aspect of a case. It could be a piece of something that's in a case. But I just want to give you a few examples. So court-appointed neutrals are used a number of different ways. I think almost anything you can imagine, but some of the common uses are for discovery purposes, where a neutral will be brought in to help manage discovery disputes, deal with privilege issues, things that maybe a court doesn't have the time to do, or there's so many issues involved, or documents or parties, that it is helpful to have another person come in and help to address the situation. We can court-appointed neutrals can be involved in what I call an allocation process, which might be if you have a settlement and there now needs to be a distribution of funds to people. Often a court-appointed neutral is brought in for those purposes. Some of the things that I've done include what I call a census, which is if you have a large scale dispute with lots of people. So I'll use Flint as an example because there are about 100,000 people in the Flint community. So that's sort of our universe of people in those cases. So the issue there was, well, what do we have? How many cases have been filed? And it's not just how many, but what types of cases have been filed? Who is the lawyer for these people? Who's not involved? You know, who would be a class member if there's a class action? So trying to get your arms around the entire scope of the claims really that are being brought in the litigation. Sometimes a neutral will deal with fee issues. So there can be lots of issues that arise in that context. I think recently we've seen neutrals appointed to do what you might call expert work, which would be providing an analysis of the valuation of claims or the aggregate valuation of claims. And then there's a more traditional use, which is kind of what I call report and recommendation. So where there might be a motion or there may be a particular legal issue, and a court might assign the analysis to a court-appointed neutral who will then prepare a report or analysis for the court's review. So, and usually those are things that can be essentially appealed to the judge. And you see court-appointed neutrals appointed in particularly some of the very large cases that we all know are out there. I guess another way in which neutrals work is to deal with cross-jurisdictional issues where you have some cases in federal court, some cases in state court, maybe in a variety of different jurisdictions where there's a coordination function that might be useful. So I'm going to stop there because it's almost anything you can imagine.
Okay. And you know what? I'm glad you gave me the opportunity. I realize in my excitement to introduce you today, I omitted a couple of housekeeping things that I should have included in my introduction. I'm sure folks might have questions. We have all of you, since we have a big enough group, there's always somebody who forgets that to mute themselves. So you're all muted right now, but if you do have a question, if you write it into the chat, I'll try to get that and get it to Debbie. And we also plan on there being some time at the end to be able to ask questions. The other thing that'll come towards the end is that Caleb, for those of you seeking CLE credits, puts the magic number up in the chat. He'll also circulate that number by email after. So I omitted not saying this. I joked with Debbie beforehand that we didn't know when we set this up that it was going to be tax day. And we're a little bit worried that, people are going to be so enthusiastic about this, they're going to forget to go to the mailbox. So please, go ahead and still pay all of your taxes. Well, that was a great outline for the types of things that court-appointed neutral would do. I think you and I have talked about this. In my experience, the first time I dealt with a court-appointed neutral as a lawyer, it was in Wisconsin State Court, and it was a former judge who they initially appointed him to do discovery disputes. So, no judges want to look at privilege logs. Frankly, it's one of the reasons why I'm not litigating actively, even though I guess I should, want to oversee some of those, disputes. But then it morphed, and he did some of the other things that you were talking about. He ultimately made recommendations on summary judgment, which frankly we weren't all that thrilled about. So what's the mechanism? And I know it's different. I just mentioned a Wisconsin State Court, so it's going to be different. But in your experience, I know you mentioned the federal rule that special masters operate under, but who delineates, who decides what your role is going to be in any particular case?
Yeah. Well, in my experience, it's the court. So the parties might actually seek to have a neutral appointed. They might not. The court might decide that there's, that the court has interest in it. And the way it's worked in my experience is that the court notifies the parties that, of a desire to appoint a neutral, and the parties will have a period of time to comment on that. The court might ask the parties for suggestions. The court might have some ideas already. And names will be presented. I think parties will have usually generally an opportunity to comment or make objection or agree, whatever it is they decide they want to do. And then the court will have to enter an order that assigns, that appoints the person and then describes with specificity what their role is and how things will work. So if there's going to be a report and recommendation, then it will say, this is what you're supposed to do. It's on this issue. This is the time frame that you're supposed to produce your work product in. And then the parties will have 20 days to object to it if there's something that they want to bring to the court's attention. So there'll be things like that that will be spelled out in the scope of the order so that you know what you're supposed to do and what you're not supposed to do. It can be changed, of course. Any order can be modified, but that's where your marching orders are in the order.
And that's interesting. As a AAA arbitrator, I don't know what goes on beyond the curtain when people are considering. So if the AAA puts my name out there, list of 10 for the parties to consider, I never know that happened. I don't know that a party may have decided, oh no, I don't want that Showwolf guy. Do the courts have a similar protocol? I imagine that would be important because you don't necessarily want to think about maybe a party or an attorney struck you from consideration,
Right.
or is there a protocol for that?
So I think it's really flexible. I think each judge has their own way of proceeding. The rules are not super specific about it. And there is an effort right now in the ABA to develop a model rule for states and jurisdictions that maybe don't have really very detailed guidelines. But generally, at least what I've experienced is that a court will either ask the parties, give me 3 names that I can consider. And hopefully the parties get together and agree on those 3 names so that the judge is the only one who would be vetoing anybody. Or the judge might say, I'm interested in this person. I'm putting this name out there for you to consider. And if you want to, talk to the person, you can do that. I mean, they sort of leave it sort of flexible. And sometimes judges just will say, I have a person in mind and this is the person I'm going to appoint. And there's no other discussion about it. So I think it's pretty judge specific in that sense. But my own experience has been that, at least when I've gotten appointed, my name has been provided to the parties and they could come back and, make whatever comments they want to make to the judge.
And are there rules and guidelines for whether it's appropriate if, say, the parties are considering 3 people, whether you actually talk to the parties to learn about the case, or is that something that you can't do ex parte, or how does that work?
So that's an interesting point. I think if there are, I think again, there's nothing that specific about that part of the process, but in the appointment order, the judge should address the issue of what kinds of communications you can have. So if you're being appointed to do some sort of a mediation role, you will need to be able to have communications with each party independently. But the order should spell out what kind of communications you can have and what kind of communications you can have with the court. So that should really be in the scope of the order, so everybody knows what can happen and what is not supposed to happen. So, but I think that I'm trying to remember now if I, in the most recent appointment, had anyone contact me before it became final think that they all contacted me right after the appointment. And I met with every party in the last one that I had, just every party independently who wanted to introduce themselves and who they were in the litigation. So I didn't even have to call anyone. They all called me, so it was fine. So
But I imagine you become popular once.
yeah, all
you
of a sudden my phone's ringing off the hook, right? So
Yeah, no, absolutely. And for you personally, you've done, we introduced you as doing work related to, mass torts, to terrorist activities. So is there also like a subject matter that you feel more comfortable with? Is there a scenario in which a court might be considering to use you in a case and you might be like, yeah, I'm not sure that this one is really,
right.
up my alley. How does that work? And how does the court know, oh, this is, there's a terrorist case outside the borders of the United States. Not many people have practical experience in that. So how do
Yeah.
people even know that, they call Debbie Greenspan?
Well, that's an interesting question. And I think the subject matter is important, or can be, but it depends on what your task is. So if you're, if someone said to me, I'm going to need you to, I'd like you to come in and assist in an IP litigation where your job is going to be to help the parties, assess the patent, the claims of infringement on a patent. And I'm not an IP lawyer and I haven't had experience in that area. And I might say that there's really somebody else that could be better at that than I would be. But if the issue in the IP case is really, parties can't agree on how to allocate their defense costs among each other or whatever, something like that, that's generic. And you don't need to have particular subject matter expertise. Some people believe that that subject matter expertise is critical in particular cases, and some people think it's less important. I personally would not be comfortable going into a situation where I really know nothing about the law, if my role is going to touch on that. A lot of what I do, though, I should amend that and say almost every case I've ever been involved in, the issue is different. That what has happened, the claims, the nature of the claims are different, but the bigger picture has a lot of similarities. And it's more, and I can go into that more if you want, but it's process, it's trying to understand what are the important features of a case, what do you have to get to in order to get, move the case forward, for example, which is another role of a neutral, to try to structure a case management process when you have a big complicated litigation. So some of those things, it doesn't matter what the underlying dispute is for those purposes. So it can go either way, I guess, the answer.
Okay. And we'll circle back, I think, to process questions in the abstract in a little bit, but I also would I think some of these questions and issues can be flushed out when we talk about, something more concrete. And I know we advertise what your, experience, is in. You and I have joked, I'm still waiting for Hollywood to do a film about anything related, to my life. So, as we said, you served with Ken Feinberg on the September 11 Victims Compensation Fund. And so I know Michael Keaton played Ken in the movie Worth. So, I know, and we'll get to this, you have another movie that you recommend people to actually watch. But if Michael Keaton played, Ken Feinberg, do you even know who played you in the movie?
I think there was a character created that was a conglomeration of people. That was the other main character in the movie. A lot of that was what I did in the 9/11 fund. So
okay, so now, and so you haven't seen Worth, correct? I actually did.
I have not seen it. No.
I'd be interested, maybe in the comments, whether, how many people here, had seen the movie, but you actually, you can hear your voice in this trailer that we're going to play, a documentary called Out of the Ashes. So you sent this to me. I'm going to, because we both decided that we thought a little video clip would be something that people, are interested in these CLEs. So I'm going to share my screen to show the trailer for Out of the Ashes, but is there anything, I know we'll talk about it on the back end, but anything on the front end that people should know about, or is this trailer pretty self-explanatory?
So I think it's probably pretty self-explanatory, but what's very interesting about it is it is a documentary. It's not a Hollywood, dramatization of anything. And it was done by a law professor. And I spent a lot of time with this professor working on this. And what I just learned so much about filmmaking. I mean, it was an amazing thing to me. I love doing it because I had never thought about how do you depict certain concepts visually. And that's a lot of what we talked about. And I think she succeeded very well on something that, it isn't a Hollywood type of movie. So it's more factual. But anyway, you can show the clip and ask questions if you want after.
We'll just let Debbie talk a little bit about this. I will put the clip into the chat. So if anybody wants to, on their own time, learn more information about the documentary, we can do that. But at one point in the trailer, you hear your voice talking about, I think you're looking at, or they're showing scans, and you're talking about, incidences where with victims, you can spot, debris in the lungs of the victim. So that had to be extremely difficult work to do. And, just if you could walk us through a little bit of, what you were doing, how it came about that you became involved with Ken Feinberg on this.
Okay, well, how I became involved is that Ken Feinberg and I were partners in a law firm together, and I've been working with him for a long time. And when this came up, I drafted up an outline, to discuss when the Department of Justice was looking for, who to appoint as a special master, which was a very political issue at that time. So I became involved right from the beginning once he was appointed, and we had 1 month, actually about 3 weeks really under the statute to set up a program, which is not very much time. And did so actually working night and day to get something set up, and did so in the form of regulations, which meant that people could then comment on those regulations and challenge them, and they did. This went up to the Second Circuit. There were issues and disputes about what the regulatory framework should be for this compensation fund. But ultimately, we got started on it, and it was a very, very intense and very involved process where families could make claims, and the job was really to determine the compensation amount for the relatives of the victims. The fund encompassed people who were killed or injured in, quote, the immediate aftermath of the 9/11 attacks. So that's first question is, what does that mean? What's the immediate aftermath? And then there was a question about what is the zone in which injuries could have occurred from that attack. And I will get there's a whole issue with immediate injuries and then latent injuries. And then, then of course there is the methodology of giving compensation. We had to determine economic and non-economic loss. So the economic loss, we have a kind of a framework in our legal system. The non-economic loss is quite different. And so there was a lot of thought put into how to structure these, the kind of process for determining a claim value. There were lots of disputes about this and about how it should work, and what should happen with people who were of different income levels, for example, and is that fair? And how do you account for those? Do you make distinctions? And lots of very, very, difficult family disputes, and lots of foreign claims. I mean, I want to make it clear that there were claimants from all over the world, and in trying to evaluate their situations and how to communicate with them. And we ended up with, kind of these, we actually had video conferences with people all over the world, because we allowed anyone who wanted to have a hearing and to come in and tell their story and explain what had happened to them and what the what the situation was. And this was not an adversarial process, which is another difference from our legal system. We didn't have somebody on the other side saying that's not the right way to look at their damages. We had, we had to evaluate each claim on its own merits. So I'll stop there because it was a very intense and very difficult process, but I'm happy to talk about any aspect of it that you'd like.
All right. Well, first of all, I think somebody asked, I didn't put the name of the movie. It's called Out of the Ashes. So you can go look at that. And, I know you didn't see Worth, but you talked, I think, to Ken Feinberg about it and decided it might not have been the most accurate. So, but let me ask you, you say it wasn't an adversarial proceeding in that it wasn't in litigation, but you had people who were making, economic, non-economic, different arguments for what their piece of the pie would be. First of all, what did you go into it where there was an unlimited pie and therefore there were dollar amounts that were available for any claim, or was there a finite number? And so therefore any recommendation that you were providing for claimant A, indirectly impacts the amount of money that's available for everybody else?
The initial fund, which is what we're talking about here, because there's now another one, but the initial fund, which started in 2001 and ended in 2004, was uncapped. There was no cap on the fund. There were certain things. There was a collateral offset provision. So if they got insurance recovery, they're supposed to subtract that from the ultimate award. A lot of people didn't have insurance and just want you, just a lesson. So that was uncapped. So you weren't taking away, but what you did have was, for example, first responders, firefighters who went into the World Trade Center building. The firefighters don't make as much money as some financial stock, somebody in the stockbroker industry or the legal industry. Those are also people who were lost in 9/11. So their economic loss might be lower. But on the other hand, there were a huge number of charities and other kinds of funding given to first responders. So they had more extensive collateral offsets. But although we didn't offset charitable contributions, and so there was a lot of issues with the fairness of the relative compensation between different people. And the objective here was to take similarly situated people and have their compensation be similar. Very hard to find similarly situated people. Everybody has their own issues. There are lots of them that can be taken into account. And I mean, I can walk you through how a claim was evaluated if you want, but we had certain goals, and that was to be transparent, to explain to people exactly why their compensation was set the way it was, to respond to questions and issues if they said we disagree because we think you should have taken X, Y, or Z into account. We'd relook at the claim and consider all of those issues and get back to them and explain, yes, you're right, or no, you're not right, and here's why. So there was a lot of communication with people, and everything was explained. But we had a certain objective of dealing with people on their individual merits, because that part of what we're doing here. And also, if you were similarly situated, you shouldn't get wildly different compensation amounts. So,
well, one thing with arbitration sometimes is that different arbitral bodies have different rules, and some of the rules are a little bit different in terms of what the basis of what an award should be, whether it's based solely on legal, whether it's legal and equitable relief. So when, taking a step back, mile high view, there are some really esoteric questions for philosophers to mull over when you're talking about, these valuations. So were your guidelines strictly legal, did you feel that you were taking into consideration special factors, which might just mean inequitable? Because I mean, I think based on even comparing people in finance and first responders, there's the thought of, well, just because the first responders didn't make as much, there's, I think, a desire because they voluntarily went into the building, to save people, that, maybe they get a bigger number. So, just not with any one particular person in mind, but just from a big picture standpoint, did you have to approach this as this was a strictly legal issue, or did you allow yourself to philosophize a little bit about some of these questions?
So I think that maybe the simplest answer is to say it was always tied to something that you could say is concrete. So economic loss, we know, there's methodologies for computing future lost income. We made choices about what sorts of assumptions to apply in making those computations. One, for example, we did not separate. If you look at the data about earnings capacity, you would see some different numbers for men and women. We did not separate them out. We combined, we had just a universal set of assumptions so that we weren't making those kinds of distinctions between people. You often in an economic loss computation, you do a discount for self-consumption, but we had a lot of low-income earners. We really reduced the self-consumption factor, because there were certain, I could go on forever about this, but we basically made some choices about how to apply more standard economic analysis to every individual claim. The non-economic component is where I think, so economic analysis has standards and had guidelines. The question is sort of, what is your future earnings capacity? Are you going to always earn more the next year? Is there, there are sort of factors there that you can then do some analysis on based on the particular individual. What do you do with somebody who's just graduated from college and they didn't have a job yet? Those are all kinds of decisions that we had to make, but were made by referring to analytical sources that we could look at and make some rational decisions about. Non-economic loss is really a more difficult issue for people who were killed in the attacks. We basically said we're not going to try to require people to determine or to show that this person who was killed actually had conscious pain and suffering, and therefore their estate is entitled to a certain non-economic pain and suffering loss. We just assumed everybody had a similar amount of conscious pain and suffering, so that it was across the board the same number for that particular component. But there are other aspects for the survivors of a victim, and I'm really not even getting into the injured people. That's a whole different aspect of this. But there are so many factors to take into account, and that's where you get where you can make distinctions based on the particular circumstances of the individual and the family.
Well, and I know you have provided seminars solely devoted to this, and we could spend the entire time talking about this, and maybe we'll have some questions at the end for it. But I think my job, I had two jobs. One is to make sure the sound worked on the video clip, and I failed that miserably. But the second is to move this along a little bit, because I know you've been involved in the Flint water claims, and in a former lifetime, my docket was mostly as a litigator doing environmental claims. So I know some of the complexities of causation and timing and things like that. So my understanding, and you'll fill in a lot more details, but the water supply contract for Flint, they were getting it from Detroit. That ended, and so they went to an alternate water source that caused certain chemical reactions within the piping and distribution system that led to allegations of, bodily injury and property damage. And so it led, which in turn led to a whole lot of lawsuits. I think what I saw was, in the neighborhood of 20,000, lawsuits. So obviously courts get overwhelmed with these type of situations when there's that many lawsuits with common, alleged, common allegations, common occurrences. So, would you say this is the type of case that a court-appointed neutral is appropriate for, and how did you become involved, in that?
This is exactly the kind of case where a court-appointed neutral or maybe several neutrals could be helpful. I got appointed to this case. The judge was looking for somebody to, I think what she wanted to start out with was to manage the fee and expense process, which the plaintiff lawyers, would track all of their time and expenses, because ultimately they would want to recover that if they were successful in the case, and to understand the universe of claims, which we called a few minutes ago a census. And I think the judge was interviewing accountants for, and this is another point, is that sometimes a court-appointed neutral does not have to be a lawyer. They can be other types of professions. But I think the judge was looking at accountants, and then I happened to meet the judge completely unrelated through another judge, through just a meeting actually that was going on. And she ultimately called me and talked to me about whether this was something I would be interested in. And so we met and talked some more, and then she floated my name to the parties. So I ended up getting appointed in that case. And I started out with those two roles that I just mentioned, and it expanded to a lot of other roles as well after we got started. But so it sort of started smaller and has gotten a lot bigger over time. So,
and I'll ask, this might be a basic question, but maybe people are thinking about this. So at the end of the day, the judge floats that. Ultimately, it goes through the process where, the parties agree on it. So walk us through, like, how is there, normally if you're an attorney, the client wants to hire you, you talk about your rates and they accept that. So who sets, does the court set your rates? Is that after talking with the parties? And as you mentioned, some plaintiffs attorneys, they work on a contingency fee. So how does that impact, at the end of the day, how you get compensated?
Yeah. So the court set the rate and established it as an hourly rate. And it was, that was it. That was what the court set. And the court order of appointment directed the parties to split any costs 50-50. So plaintiffs are 50%, defendants are 50%. Ultimately, one of the very first things I did was to put together, at the request of the defendants, an allocation among the defendants about how they would pay for common costs. That would have been my costs and other kinds of things like third-party discovery and all that, how they were going to split the cost, because they didn't feel that an even split was correct in that situation. So I put together, I met with everybody, I had little letter briefs, and then I wrote up an allocation formula. Nobody objected to it, and that's what went into place. But that's how I see on the chat, it was a typical court-ordered hourly rate for a special master. I think that it's hard to say what's typical, because I think it will be jurisdictionally driven, and it will be based on what maybe others doing similar work in a jurisdiction would be charging for their services. So I think it can be all over the map. I don't know how else to answer that question. It'd be interesting probably to pull some data on that and see what the different ranges are. I can tell you that the rate that the judge has set for me is half of my normal hourly rate. So And then what administrative or other support do you rely on in these cases? I'm seeing the chat pop up, so
Yeah.
I'm going to try to answer
And,
those questions.
and I'm looking
So-
at it too, and so I can, you know, if there's a question like you've been doing that you want to address instantly, that's
Yeah.
fine. Otherwise,
I can do that. So for the work that that I have been doing in this case, I have been fortunate because I'm in a law firm, so I can draw on law firm support. So for some things, I have used our IT department to kind of put data into a particular format. I can draw on a couple of other attorneys. I try to keep that very minimal. And just use what support I need. Some special masters or special neutrals and court-appointed neutrals will hire an outside vendor to do some of the work when we're talking about things like collecting data on cases. I did that all in-house, and I did it in-house primarily because I wanted to, I basically policed this process. I looked at what people were submitting. I went back to all the lawyers and said, this isn't clear enough. You know, we need better data here, you know, so I did this in a very direct, hands-on way, so that at the end of the process, we had a really good collection of case data for, you know, for use in settlement discussions.
Okay.
Primarily, so.
and I didn't mean to open a Pandora's box when you've got a bunch of lawyers together about fees. So I see there's some other questions about that, but I'm gonna move us along a little bit. So we've talked about 9/11, we've talked about Flint, Michigan, which really became the poster child for environmental justice. And so you have a lawsuit, but you also have it within the framework of our political environment. And clearly there were political issues for 9/11 as well. So how, you know, with these high profile cases, you know, how do you, as a neutral, avoid getting sucked into kind of the national conversation about things like environmental justice in Flint?
Well, I think you have to kind of step away from those conversations because you really can't have a position as a neutral, but you should be aware of it. You should be aware of the effect of everything that you're doing on how people are perceiving the case and perceiving whether the system is working or not working. That has a lot to do with communications. One of the things I do in the Flint case is I provide periodic written reports and oral reports at status conferences. And I try to provide information that will be useful to people so that they will understand what's going on. And, you know, and if they don't, I just before this, I had a call from a plaintiff, and that, you know, people call because they can find my contact information. So I get calls from people and I try to direct them back to their lawyers if they have them, but I basically provide update information so people know what's going on, but I'm not taking a position on whether something is right or wrong. I do want, if people want to talk about it and want to give their impression or their position or their views, I will always listen, but I'm not sort of ruling on, you know, is this right or wrong? One of the things to know about Flint is that there are governmental entities involved in the litigation. And so it gets even more political when you have something like that involved in the case. So you have a lot of very public commentary in the political system about the litigation.
Well, you also said that you presented an allocation to multiple defendants on how they would pay, you know, for certain costs, and that got accepted. I you know, somewhat tongue in cheek, want to know your secret sauce because, you know, last week I had a mediation with multiple defendants, and we spent the entire day talking about how you should properly allocate. But
Yeah.
what type of defendants are we talking about here? You mentioned some governmental entities, but, you know, walk us through who gets sucked into these type of cases because it's so complex and everybody's pointing the finger at everybody else.
So this is as you described earlier, Flint is particular, but also I think there are a lot of other cases like this out there or about to be out there. This is a municipal water system, and the municipality decided to switch providers. They were getting water from Detroit system, which had been treated water. They've been doing it for 50 years or something like that. And they wanted to go with a new system that they thought would be cheaper in the long run. It just wasn't ready to get started yet. And so they used the Flint River as an interim water source while waiting for this new system to be up and running. So the defendants include, of course, the city of Flint, but there were 3 emergency managers, there were mayors, there were different people that were officials in the city making decisions about what to do, their defendants. On the state of Michigan side, it's multiple individuals, including the governor. The then governor is defended in the litigation. There were people from the, basically the DEQ, the Department of Environmental Quality, that were also involved in making decisions about or overseeing how municipalities comply with the various water safety standards. There are other defendants, include engineering companies. There were 3 of them that had been involved at one point or another in advising about what could be done, how you could use this source, what you have to do to treat the water, different kinds of questions that were posed to them. And the EPA is also a defendant, but their case is separated out because it's under the Federal Tort Claims Act and it's sort of a different kind of proceeding. But those are the defendants. So it's the different governmental officials, private engineering companies. Oh, and there's a hospital that is involved as well, because people were in that hospital and were sick, and the allegations are that they did not properly test the water. And so people became sick because they were in the hospital and exposed to this water. So that's our group of defendants. And there were several class actions filed, and there are about 20,000 individual cases, almost all in federal court, but there are some in state court as well.
Now, I think it's probably fair to say that the courts and even the parties don't want to see their 20,000 separate trials on this. So my understanding is that they've had what's called bellwether trials, and one took 5.5 months and led to a hung jury last year. So why don't you tell us a little bit about what a bellwether trial is and what its utility is within the framework of possibly seeing if there can't be a more global type resolution to avoid all these trials?
So I think what's important to know is that all the stuff that happens before you get to the trial stage, which we all kind of know about, but it's magnified in this situation. There's of course motions to dismiss. That's the beginning. And this, with the governmental entities, it was the claims in the federal court are constitutional torts. And so there's a question of qualified immunity. Those issues were addressed. They went up to the appellate court, and when cert was denied, it came back. So there was all of that beforehand. At the same time, there was a lot of discovery going on. There were, hundreds of depositions taken to kind of get, all of the facts out there and all the documents out there. And so we get through all of that. The case is not dismissed. Some parties were dismissed, but many of them continued in the litigation. And so we get to the point of a bellwether trial, which is intended really to sort of give a sense of what, to help everybody understand how successful these cases can be or not be, and what it's going to involve to litigate them. And that will inform, if there, some just settlement discussions possibly, or other actions in the case. So there was a bellwether trial that started last year in 2022 in January or February. It went till August, and it involves 4 children whose claims were that they had cognitive neurological deficits as a result of exposure to lead. So you have in there, were they exposed to lead? Were they exposed to lead from the water? Can lead cause these kinds of injuries? Do they have these injuries? That's all about, that's one piece of it. and then how to value their damages if they do have those injuries. And then the front part of it is, who is responsible for this? Who did somebody breach any obligation or duty that they owed to these 4 children? So that was the bellwether trial, and it really is intended. I thought it was, even though it resulted in a hung jury, it was extremely informative in terms of understanding how this litigation can be managed and put together. So right now, so that trial ended in a hung jury. There's currently on the way to in the sort of stages. I think we're getting close to Daubert motions and the like in a class trial. So there is now a class that's been certified for certain issues. It's an issues class under the federal rules, and it is against 2 private engineering companies. Those are the defendants. The class is defined. It's got a very specific definition of who's in the class. That trial is scheduled to start on October 3rd in federal court. And then early next year, there are 2 more bellwether trials lined up to go with different plaintiffs.
Well, I find it fascinating that a hung jury was still very helpful, right? Because from my understanding of bellwether, trials, if the plaintiff rings the bell on that first bellwether, the price of poker goes up for the defendants. If it's a defense verdict, then it drives down the price. Let me just ask you this, because we're getting pretty close. Do you observe the bellwether trials? I mean, it went for 5.5 months. I know you have other practice. So how is it that you're becoming apprised of it? And are you doing it for the purposes of potentially negotiating settlement, or what's the purpose for you to be apprised of bellwether?
So I should explain that there is a partial settlement that was reached with the governmental entities, and 1 engineering company and 1 hospital. So there is a partial settlement, and I'm spending a lot of time managing that settlement process right now. That was another, a role that the judge assigned me to. The trial process is going forward against 2 other engineering companies, and eventually the EPA, which is another defendant that's going to go to trial. I did observe, it was because this was broadcast on Zoom, the trial, I was able to observe it without traveling and sort of moving to the trial location. And so I did observe it. I watched it every day. Sometimes I didn't see the entire day's events, but I did see every witness. And I want to assure people I did not charge time for that. I just did that because it was something the judge asked me to do, and because I really did want to see how it played out in the litigation, because it is informative about how to proceed with any further discussions about any resolution or management of the trial process. So I did watch it, and it was great because it was on Zoom, like I said, and it was very accessible and very easy to see, what could be done differently from the way it was done, and is there a way to streamline some of this and deal with some of this in a quicker way. So that is helpful to the process of the litigation.
All right. Well, I know a lot of people here do pro bono, mediation. So they take it to heart that you didn't bill for, at least a portion of that time. 2 last thing. We had Molly had a question. Are court-appointed neutrals required to be or to have been practicing lawyers? So if you could address that. But I'm also going to give you a little bit of an opportunity, and it's not much, so I apologize, as the president of ACAN. If you could tell us a little bit, obviously you've got an audience of people who were interested, in knowing a little bit more about court-appointed neutrals. It's not the most difficult place to get into because they accepted me as a member. So some people, might be interested a little bit about how they can learn more information about that and how they can become involved in that.
Sure. So the first question is, no, you don't have to be a practicing lawyer. it depends on what you're being asked to do. I think I mentioned that the judge in the Flint case was looking at accountants to sort of track data, thinking that that was an expertise that would be useful for certain functions. So you don't need to be a practicing lawyer. There are lots of people who are former judges who do get appointed, I think, in this kind of role. And they're not necessarily practicing law in any other capacity. So there's a lot of flexibility in it. I do find that judges like to appoint people who are in their jurisdiction. You know, I'm in Washington, D.C., and I'm appointed in the Michigan case, but I am barred in Michigan, and I went to school in Michigan, so I have a lot of Michigan ties. And so that was, I think, pretty easy for the judge in that sense. So I hope that answers that question. And then you asked about ACAN. So ACAN is the Academy of Court-Appointed Neutrals. It's a group that is, you know, people who are kind of in this area or interested in it can join. And the objective is really to create, you know, we have training materials, we do training sessions periodically. You can collaborate with other people in the group to kind of cross-pollinate and sort of help each other out and develop best practices. We have a bench book, which is a very detailed book on how to use neutrals and how to find neutrals. We actually have a, you know, a kind of process right now where if you're interested in getting in touch with a neutral who's one of the a member, you can make a request, and then that will be sent out to all of the members, and they can respond and say, I'd be interested in talking to you about this particular case. We've had inquiries from judges and from parties looking for somebody. It's not intended to assign somebody. It's not like AAA or something where they might say, here's your panel. It's really just you know, it's just transmitted to everybody, and anyone who wants to respond will respond to that inquiry. So so it's open-ended like that. It's not a pre-selection type of process. But I think the main focus of it really is to educate people about the uses of neutrals, educate the judiciary, educate practitioners about it, and develop best practices and guidelines and standards and ethical guidelines so that people know that if you're somebody that came from ACAN, you've been through this kind of training and orientation, you have some basic knowledge about how the process ought to work and some guidelines that you might want to follow or should follow. So, and actually, I think it's a very good group. So we have a meeting once a year, like an annual in-person get together once a year. We will probably be expanding to having a little bit more remote gatherings during the year, but we've always sort of focused on a once a year get together. We just had ours in March for this year, and next year will be in March as well in Florida, in case you're interested. We've been told that we have to go to a warm environment if we're going to do it in March. So I hope that's enough information about ACAN. We have a website, so you can look it up.
Well, thank you very much. I forgot that we both, you know, are U of M alums, you know, at least for law school. I think you went undergrad too, didn't you?
I did. I just stayed there. It was easy. Yeah. So.
Well, yeah, you're not going to pull Texans in March to go up, like, say, to Ann Arbor. You know, so that's not good.
Still snowing. It snowed yesterday in Ann Arbor, so I'm just saying, yeah, you probably don't want to go there till July. So.
Well, Debbie, on behalf of the Austin Mediators Association, the ADR sections of both Austin and the San Antonio Bar, we very much appreciate your time. I think this was fascinating, and you know, thank you very much.
Oh, my pleasure. Thank you so much for having me. I really appreciate it. Thanks, everybody.
Thank you.